5 seconds to go. Start. The injuries so caused or continuing injuries are the cause of action arising therefrom is renewed de die indium, and as against defendants 5 to 9, the cause of action arose to the plaintiffs on 29 December 1949, the date on which the defendant number 7, the city magistrate Faizabad cum Ajodhya, attached the mosque in suit and handed over possession of the same to Shri Priya Dutt Ram, defendant number 9, as the receiver, who assumed charge of the same on January 5, 1950. The state government and its officials, defendants 6 to 8, failed in their duty to prosecute the offenders and safeguard the interests of the Muslims. In the suit, as it was originally filed, a declaration was sought to the effect that the property identified by the letters A, B, C, D in the map annexed to the plaint is a public mosque known as Babri Masjid, and the land adjoining it, depicted by letters E, F, G, H, is a public Muslim graveyard. Prayer B seeks a decree for the delivery of possession of the mosque and graveyard by removing of the idols and other articles of worship placed by the Hindus in case, in the opinion of the court, delivery of possession is deemed to be the proper remedy. Prayer BB is for a command to the statutory receiver to hand over the property described in Schedule A by removing the unauthorized structures. Prayer BB was brought in by way of an amendment on 25th May 1995. The plea of limitation was specifically raised in several written statements, among them in paragraphs 27 and 28 of the written statements of the first and second defendants and paragraph 23 of the additional written statement. The plea of limitation was also raised in paragraph 35 of the written statement filed by Nirmohi Akhada and Mahant Raghunath Das, defendant numbers 3 and 4, in paragraph 29 of the written statement of the Akhil Bharat Hindu Mahasabha, defendant number 10, and in the written statements of several other Hindu parties. The 10th defendant filed a written statement on 15th February 1990 and denied paragraph 23 of the plaint. In the additional pleas raised in paragraphs 29 and 79, a specific plea was raised that the suit is barred by limitation. Paragraph 79 of the written statement reads thus: that the suit as framed is a suit for declaration only, and the relief for delivery of possession is in the words that, in case, in the opinion of the court, which means that the plaintiffs are not seeking relief of possession and leave it to the court to grant possession suo moto. The reason is obvious that the suit was barred by limitation, and so specific prayer has not been made. Paragraph 39 of the written statement was inserted pursuant to the order of the court dated 23rd November 1992. A replication was filed to the amended written statement of the 10th defendant, but there was no specific traverse of paragraph 79 of the written statement. The suit was presented and filed on 18 December 1961. The first plaintiff of suit 4 was impleaded as the 9th defendant to suit 3 instituted by Nirmohi Akhada in pursuance of the order of the court dated 23rd August 1989. A statement was made on behalf of the first plaintiff through counsel that the written statements which were already filed on behalf of defendant numbers 1 to 5 in suit 5 and defendant numbers 6 to 8 in suit 3 were being adopted. Sunni Central Waqf Board was also impleaded as defendant number 10 in suit 1 pursuant to the order of the court dated 7th January 1987. Stop.